Good evening. Now, since independence in 1964, Zambia's search for a durable, widely accepted constitution has remained a major national challenge, shaped by mistrust, executive influence, and repeated review processes whose recommendations have not always been upheld. Today, the issue has resurfaced with Constitution Amendment Bill number 7 of 2025, which has sparked intense debate. Supporters of the bill say it will fix inconsistency and strengthen governance ahead of the 2026 general elections, while critics of the bill warn that it may repeat past mistakes and threaten key democratic safeguards. Tonight, live from the Diamond Media Studios, we bring government representative and the opposition together for a balanced and issue-focused national debate. To help citizens follow and understand the discussion with clarity, the debate will center on two major thematic areas. Number one, the process behind the Constitution Amendment Bill number 7, and secondly, the substantive content contained within the bill. This, remember, is an important moment for public dialogue and national reflection. For those watching us live, you can follow the discourse via the following platforms. We are live on Diamond TV on channel 271 on DSTV and channel 20 on GoTV. We're also live on Musanza Television on Topstar channel 93, Prime Television on DSTV channel 273, GoTV channel 21, Topstar channel 103 and Star Times channel 543. We're also live on Mafken TV on Topstar channel 171 on the Copperbelt. You're also catching this conversation live on the following radio platforms: One Love Radio in Lusaka on 102.3 FM, in Joma on 102.3 FM, and in Mansa on 89.1 FM, in Kasama on 94.9, in Mongo on 87.7, and in Siavonga on 91.5 FM. We're also live on Mafken Radio on the Copperbelt on 97.7 FM, Radio Mano in Kasama on 89.3 FM, Radio Delight Kwitonta in Muchinga Province, Chinsali 89.7, KFM in Mansa 95.5, Millennium Radio here in Lusaka on 90.5 FM, Power FM in Lusaka on 91.3 FM, Power FM in Kabwe on 91.3 Power FM Kabwe on 87.9, Power FM in Livingston on 102.4 FM, Yar FM in Kitwe on 89.7 FM, Breeze FM in Chipata on 89.3, also covering Chadiza, Mambwe, Lundazi and Nyimba, Petauke, as well as Sinda, and finally on Kanele FM on 97.7 FM. Thank you so much to these media partners for accepting to be part of this conversation. To our live audience as well, you can also take part in this discussion via Zoom, link available on the Diamond TV online Facebook page, as well as Diamond Media Zambia. Right now, allow me to introduce our two panelists for this evening's debate. And to my right is State Counsel Sakwiba Sikota. Good evening and welcome to this debate.
Good evening, Costa. Good evening, viewers. And good evening, President Hakainde at Community House. I know you are watching. Thank you so much.
Representing government is Minister of Foreign Affairs, but coming in his capacity as State Counsel, Mulambo Haimbe, MP. Good evening and welcome to this debate.
Good evening, Costa. Good evening, viewers. Good evening, listeners. And of course, the nation at large. It's wonderful to be here for this important exercise.
Thank you so much. Very quickly, for the sake of the viewers and for the sake of the discussants, I'll just run and set the ground rules for this debate. Each one of you will be given 3 minutes each for your opening statements. Thereafter, you will each be accorded 2 minutes in which to respond to questions that the moderator will ask. You are free to have 1 minute of rebuttal on any issues you want to clarify if necessary. As moderator, I may allow brief follow-up for clarity when necessary. Direct exchanges. As moderator, I may initiate a head-to-head segment where the both of you may respond directly to each other. Each speaker must wait to be recognized before speaking. Cross-talking is not permitted, and the moderator may or will cut in to maintain order. Time management, as explained, we have a timer in front of you. If any participant exceeds the allotted time, the moderator will intervene and stop the speaker. As participants, you must respect time limits to ensure fairness. Obviously, we expect that your state councils, so your conduct and decorum is one, obviously, that is respectful, professional, and obviously no personal attacks, inflammatory language. Those are strictly prohibited, and as participants, you are strictly called upon to focus on issues, facts and legal arguments, not personalities. I hope those rules are clear.
Absolutely.
Thank you so much. As we start this debate, allow me quickly to turn to a video, really just to set the stage on what's at stake in the Constitution debate and Bill number 7.
Let's start with the part that has captured Zambia's attention. This is not just another legal document. Bill 7 has become one of the most talked about and contested proposals of this administration because it goes to the heart of power, representation, and how Zambians choose their leaders. At its core, the Constitution Amendment Bill number 7 of 2025 proposes changes to how Parliament is formed, how elections are run, and who gets represented. Supporters call it overdue reform. Critics fear rushed change, and in between lies a nation asking, why now and at what cost? So how did we get here? To understand Bill 7, we need to zoom out. For over 30 years, Zambia has repeatedly tried to reform its constitution. From the Monakatwe Commission in the 1990s, the Mungombe Commission, the National Constitutional Conference, the Silungwe Technical Committee, and multiple electoral reform processes. But one theme keeps returning. Representation has not kept up with Zambia's population, geography, or democracy. Some proposals made it into law, but many also did not. The 2016 Constitution itself was a compromise passed, but leaving unresolved questions about constituency size, inclusion of women and youth, election petitions and by-elections. Bill 7 is the latest attempt to address those unfinished issues, drawing heavily from long-standing recommendations that have resurfaced across decades of reform efforts. So what exactly is Bill 7 trying to do? In simple terms, Bill 7 proposes 3 major shifts. First, delimitation. Zambia still has 156 constituencies, a number set almost a decade ago. Despite rapid population growth and vast geographical imbalances, some MPs today represent areas so large they're almost impossible to service effectively. Bill 7 proposes increasing constituency-based seats and updating boundaries using recent census data. Second, a new electoral system. The bill introduces a mixed member proportional representation system. That means Parliament would be made up of members of Parliament elected directly from constituencies, as is currently the case, and MPs allocated proportionally through party lists, specifically to increase the representation of women, youths, and persons with disabilities. This is a significant shift from Zambia's long-standing first-past-the-post system. Third, institutional cleanups. Bill 7 also touches on by-elections, nominated MPs, timelines for election petitions, definitions of youth and adulthood, tenure rules for ministers, mayors and senior legal officers, aiming to reduce ambiguity that has repeatedly ended up in court. So why is this happening now? The government argues the timing is driven by data and necessity. Zambia's population has grown sharply since the last delimitation. The Constituency Development Fund is spread thin in oversized constituencies. Women make up over half the population but hold a small fraction of parliamentary seats. Youths and persons with disabilities remain largely absent from decision-making spaces. To guide this process, a technical committee was appointed in 2020. It conducted nationwide consultations physically and virtually and received nearly 12,000 submissions from citizens, civil society, traditional leaders and political actors before producing its final report and draft bill. So let's talk about the controversy and the question marks that have risen. Despite that process, criticism has been loud. Civil society organizations, including voices within the Oasis Forum, have raised concerns about the pace of the process, whether consensus is deep enough, fears of reform too close to an election cycle, and whether Parliament, rather than the people, ends up with too much control over constitutional change. Others question the cost implications of expanding Parliament and whether proportional representation could weaken the direct link between voters and their members of Parliament. Supporters respond that none of these ideas are new, that they reflect decades of public submissions, and that delay has already come at the cost of fair representation. So why does this matter? This debate is not just about legal clauses. It is about whether Zambia's democracy reflects who we are today, not who we were 10 or 20 years ago. It is about balancing stability with inclusion, speed with consensus, and reform with trust. Bill 7 has not yet rewritten the Constitution, but it has already forced a national conversation about power, fairness, and participation. And that conversation, informed, critical, and grounded in facts, is exactly what a constitutional moment demands.
Thank you so much, Justin Mlenga, for laying context on what we're discussing tonight. Before we get into this debate, very quickly, we had a chance to speak to ordinary Zambians, and here's what they have to say.
My name is Pulu. I have heard of Bill 7, but I haven't gone through the details. I haven't really read it in depth.
My name is Naomi Banda. I've heard of it, but I'm not really aware of what it entails.
My name is Linda Chalwe. No, I'm not quite familiar with that.
My name is Christopher Nenguke. Constitutional amendment, I think I'm aware. Nina imvelapo and ninizwa ku 1 or 2 3 things. Vane vikambika mmoja kuti vanefunga kuti vichinje.
Yeah. Stiziva.
My name is Trinity Mwansa. Yes, I have heard of Bill 7, but I haven't really paid attention to it.
My name is Paul Katema. Yeah, I'm aware about Bill 7.
My name is Afano Ndlovu. I've heard about the amendment of Bill number 7.
And what my take about B7, I can say, at this moment, we as citizens, we can think it's just a political move. While it's a thing, it's something that the president wants to implement for improving the number of youths in parliament, number of women, people with disability. On my part, I can say it's good, but again, the position or the point where this Bill 7 has come in, it's not a right position. So I could say that the government should pause this Bill 7 and propose it again after the elections. Because as we can see, next year is an election year. And then people will see that, okay, it's just a political move where they want to gain numbers. Well, that's not the agenda.
From the information that I've got and the issue of, not really having by-elections when an MP dies or resigns, that one I feel it is a good one in that it will save money because we waste a lot of money on by-elections and other things.
I've heard that so many bad reviews. That's not good. They don't think they should amend anything.
As a young person, I'm in support, like me myself, my opinion, I'm in support of Bill 7 because having looked at Bill 7, there are a lot of changes that are so important. Like when you look at the world, or when you look at Zambia, each region where people live or stay, it's dynamic. It keeps on changing. So looking at one aspect in Bill 7, which is the limitation of the constituencies, that's very important. Because now, look at we youths who are enjoying the funds coming from CDF. Like me myself, I've got relatives, like direct relatives, I've got friends who've enrolled in different courses through CDF. But look at the funds which have been allocated to these constituencies. Some constituencies have been unfortunate. Why? Because they are so large. Thereby, when funds have been allocated, it's not like there is no equality with those constituencies which are small. Look at Kanyama constituency. It's so big such that even if funds were allocated to Kanyama constituency and other constituencies, the benefit of youths, the benefits of the aged, and the benefit of all the members of the constituency won't be equal.
Yeah, actually, kurifuti yama youth, because me, I'm just 34, and I'm 35 years. So my youth now was timera kuti my youth at least wazaka kona representation ku parliament, which is good for the youth. Also naona kwa futi ati wazimai na wewe wafuna na wewe wafake kona wewe wazicha ku participate ku parliament kushakoma decision making machani mu parliament. I think that will be the benefit. In fact, the benefit ina kuma constituency bakaya juba, even the development is aoneka because bakaya juba kama mbikabiri katatu ngati muri masukuru ya 30 yazakangana 15 meaning they are even to construct more schools muri constituency mozi because apa munga 40 million yamene bwera next year pali constituency bakaya juba. I think it will benefit a lot of people. Ma grants na jameno wakamba ko maloni mu constituency mo development funds. I think those are benefits direct here ku muntu aliyense. Sure.
There will be a lot of benefits in delimitation. There will be a fair share of the cake, of the money. Let's look at Lusaka Central. We are here in Kulima Tower, you're in Lusaka Central. When you go as far as Bowlen, it's still Lusaka Central. So let's assume it was cut into two. From, let's say, Longacres up to Bowling, another constituency. From Longacres up to here, another constituency. Meaning, the privileges which are there, which were in one constituency, will be divided into two. So I think it's a good thing, because even a lot of people will be employed.
Discussants, viewers and listeners, those are views that we collected from the streets of Lusaka for Zambians to add their voice to this important national discourse. Allow me now to get straight into the debate, and I will start with you, State Counsel Mulambo Haimbe. Now, the initial attempt to amend the constitution when the bill number 7 was put on the floor of Parliament in March this year by Minister of Justice Princess Kasune, we were told it lacked sufficient public consultation, leading to government to defer the bill. Part of the question, was this an oversight on the government's part regarding the correct process for constitutional amendment? Later on, a technical committee, as we all know, was later appointed by the president and given a very short time, according to others, to collect this submission. They've gathered just under 12,000 submissions across the country. Again, does the government consider this a genuinely people-driven process given this limited time? And finally, I think the bone of contention on the issue of process, the Celestine Mukandila and Munia Zulu versus the Attorney General case, it declared the process leading to Bill 7, in other words, unconstitutional. Many lawyers say the ruling used the words, and I quote, against the spirit of the Constitution. Tell us this evening, in your first opening remarks in 3 minutes, as State Counsel, is this process with the new technical committee a validated and legal process, or is it flawed? And what does it mean when the court says against the spirit of the Constitution? State Counsel Haimbe.
Thank you very much, Costa, and let me begin by thanking State Counsel Sakwiba Sikota for bringing up the challenge. Of course, it was initially to President Hakainde Hichilema. I issued a counter challenge, and State Counsel has been magnanimous enough to be here this evening. I think that's a sign of our democracy maturing step by step, day by day. So thank you very much, State Counsel, and of course to Diamond Media for being also responding, being a good citizen by responding to this particular national event. Thank you. And for the others who are syndicated, we do not take this for granted. It's an important platform for us as Zambians. In your request for my opening remarks, I think you were pretty specific. I would like to instead give a historical context to start in my 3 minutes. Bill 10. Bill 7, beg pardon. We were dealing with the earlier bill some time back, and I'm sure we'll discuss it in the context of this particular bill as well. Bill 7 and constitutional reform review that is being undertaken under the New Dawn administration has got a historical context to it, and I'll be very brief about it. It's important for the people out there to understand what this context is. There is a suggestion in these conversations that we're having now that the process is rushed, that somewhat the government is now moving to make these amendments at the very last minute. To the contrary, we began this process at the time that I was actually serving as Minister of Justice, way back in 2021. The initial thought process was to have a holistic review of the Constitution, really what is referred to as constitutional reform in the strict sense of it. But as the time went along, it was quickly realized for many reasons, amongst them the fiscal situation in the country, the fact that we had and continue to have challenges for quite a bit in terms of availability of funds to run this process. By the way, a holistic constitutional review process requires, if it is to be complete, the conduct of a referendum in relation to Part 3 of the Constitution, the Bill of Rights. And so just before I switched portfolios, we again engaged the public and made it clear that looking at the situation, looking at these parameters, our views were that as government, as the executive, were that perhaps let us begin with the non-contentious issues, take a phased approach to the constitutional amendment and subsequently reform process. So you'll note here, dear viewers and Costa, that I have mentioned two things: amendment and subsequent review process for the entire constitution. We said, suggested to the public that as the executive, we can see clear low-hanging fruit in the sense of non-contentious provisions, which will help us, for the lack of a better term and to use somewhat layman expressions, to clean up the constitution. Matters which are of immediate necessity in order to see that we are able to have a more inclusive democratic process, electoral process. This is what has led to where we are. Whether or not the bill is illegal is something that we'll be discussing shortly. I can certainly say in my opening remarks that that is a complete and total misconception, a misnomer, a deliberate effort on the part of those that do not support the bill and the efforts of government to make it appear that the process is non-inclusive. And I'll be clear in my explanation. We've got all the documentation here. We'll have a wonderful night so that our people, as you could see in the video, some did not even understand what the process is. I hope that by the end of this evening, we'll have a clear picture, an honest picture of what is going on in terms of Zambia's constitutional review process currently underway. Thank you.
Thank you so much, State Counsel Haimbe. I'm sure that you've got a few seconds left, but
6 seconds. I'll cede them.
We'll allow and go straight to State Counsel Sakwiba Sikota. Good evening once again, and thank you for joining us. The issue really is about the legality of this. Any response, and do you have any specific concerns with the process that government has used to pursue these amendments or reforms, as he calls them? Again, to you, we'd like an interpretation. The Celestine Mukandila Zulu versus Attorney General case, did it consider the process of Bill 7 flawed when it said against the spirit of the Constitution? Is the technical committee and the whole process void ab initio, State Counsel?
Thank you very, very much. And I'd like to state that us as WOZA are happy that President Hakainde, that you accepted the challenge, even though you found a bit of restraint in coming yourself. You accepted the challenge and sent somebody to represent you. So I take it that what we're saying is directly to you, because that was the whole purpose of the challenge. You being the head of the nation, it's important that this matter is addressed by you. It's important that you recognize that it is a very important matter. It is part of governance. You cannot say that you've got other things to look at when the issue of the Constitution is on the table. It should be paramount by any standard. I think the Constitution, Mr. President, should be looked at as being paramount, because if you look at our country, there's three main things that you have to look at: the flag, the national anthem, and the Constitution. With all three, the people of Zambia must feel to be a part of it. Otherwise, the essence of those falls away. Everybody should feel they are part of the flag. Everybody should feel the heartbeat of the national anthem. Everybody should feel protected and that they own the Constitution. So the flag is like the face of the nation. The national anthem, like the heartbeat of the nation. The Constitution, however, is even greater than all these. The Constitution is the soul of the nation. So it is expected, Mr. President, that nobody would sell their soul. We as Zambians do not want our soul, our Constitution, to be sold. Justin Mulenga, who you played a clip of, I hope that President Hakainde actually heard him. I think that he started off by reminding President Hakainde that this is the most contested, and I'm quoting, Those were his words. The most contested constitutional process that we've ever had. That says something. A majority of the people who came in to give their views said that, in fact, they didn't know much about Bill 7. A few said they knew one or two things, but the majority actually said they didn't know. And what is instructive is that you are even talking about people in the urban areas where there's much more communication. I didn't see a single shot from a rural area. One wonders whether the rural area people were even able to have something from that. Turning to the issue of the Munya Zulu. Mr. President, if you read it, the Munya Zulu judgment says in one portion, and I will quote, "Accordingly, we hold that the Constitution of Zambia Amendment Bill number 7 of 2025 was not generated through a constitutionally compliant process and is therefore unconstitutional, invalid, and a nullity." That is in black and white. That is not distorting what the court said. It is quoting directly what they said.
I'll have to cut you there. Your 3 minutes is up. But stemming from there, quoting the Celestine Mukandila and Munya Zulu versus Attorney General, State Counsel Haimbe, you say you have the law that you want to quote for us. In 2 minutes, State Counsel Sikota says the Court says it's a nullity. It's unconstitutional. So where do you draw the strength that this process is legal? Your 2 minutes.
Thank you very much, Costa. And again, interesting that we always have different interpretations of reality. Quite clearly, we can see that our colleagues who are not in support of this bill have got a distorted understanding of the reality. You actually played clips which predominantly were from Lusaka Central. I know for a fact, as MP for Lusaka Central, that the people of Lusaka Central that we deal with and work with every day are well aware of Bill 10. So it may be that in that clip we had a couple of people who, Bill 7, beg pardon, I keep coming back to that because we will talk about it. But it's important because I know for a fact that we have had processes where we've talked to the people. We have sensitized them about this bill and what it means to them. So you cannot take those that were shown on the clip at the beginning as a representative sample. And by the way, I also want to confirm that indeed President Hakainde Hichilema is very close to this process. But being the democratic president that he is, he has said, let the people discuss this matter. Let them speak to it, and it is equally important with all the other matters that they're dealing with, that we are dealing with as a government. Now, I note that State Counsel, in quoting what he says is this decision, the Celestine Mukandila case, did not specifically mention which paragraph he was quoting. But suffice to say, and again looking at the 2 minutes, the actual decision, which is at page J25, paragraph 56 of the decision, does not speak to any of the matters that State Counsel has referred to. Maybe he's talking about something that was said orbiter, but I didn't find any of that within the reading of the judgment. What does it actually say? In the reliefs that have been granted, it talks about, and I quote, "We declare that the decision of the respondent to initiate a constitution amendment process before undertaking wide consultations with people goes against the spirit of the constitution." There is no mention of it being null and void. But more importantly, it states in paragraph 2 of the holding, which is what the court says you must follow, we order that the respondent complies with the spirit of the constitution.
I'll allow you to finish. Just take note of that. I'll allow you to finish.
We order that the respondent complies with the spirit of the constitution by ensuring a people-driven process led by an independent body of experts in conducting wide consultations with the people. The question then is, what did the court order? It said wide consultations. It didn't say stop the process of amendment. It didn't say now and void in its decision. Let us be honest with the people and speak to what is actually there.
You. Director, if we could just also beam the judgment on the screen so that we follow. You've been quoting page
J25, paragraph 56. 1 and 2.
State Counsel Sakwiba Sikota, you've been challenged that what you're quoting is not from the judgment. What is your response in terms of why you feel that this process is an illegality?
Thank you very much. It's interesting that my learned colleague states he has read the judgment, and he says that those words I've read out are not in the judgment. The truth of the matter, which he knows very well, is that those words are there. He tried to have an escape clause by saying that, oh, maybe it was Obita. That is what he says. But as to whether or not those are there, they are there. And he knows it. And that is a fact. Now, the final ruling of any judgment states that this is now what we order. But in the run-up to that final holding, they give the reasons why they are going to make that order. Now, the reasons why they were saying that that process has to be restarted afresh is because, according to them, the Constitution of Zambia Amendment Bill number 7 of 2025 was not generated through a constitutionally compliant process and is therefore unconstitutional, invalid, and a nullity. When something is a nullity, it means that it does not exist. I think Lord Denning, it is in the case of McFoy versus United Africa Company Limited, said, if an act is void, then it is in law a nullity. You cannot put something on nothing and expect it to stand. You cannot reasonably expect to build on nothing. The court has said it was a nullity when arriving at this direction that you have to start afresh. They gave that direction because it was a nullity. That is the reason why. I think that you could also let me have another extra 35 seconds as you did with my colleague. This thing must be balanced.
Finish.
Yes, thank you. And so we have to look at the whole thing holistically and confirm that the court said start afresh. Starting afresh does not mean going back to what you were doing. Starting afresh means that that is put aside and you are actually starting afresh, which they have not done.
Thank you. There still remains an unanswered question here. State Counsel Haimbe is saying the court ordered that the process be started afresh, and this is No. Correct? Well, you believe that the process, based on what the court said, is legal, and the formation of the technical committee allows for wider consultation, correct?
Yes, and if you allow me to elaborate, you said...
So what I wanted to do, yes. I'll give 3 minutes for each one of you. I won't intervene, but I'll allow for you both to exchange, because what is interesting here for me and the nation, we've got two state councils who are failing to agree on one court judgment. So then for laymen, it's even more confusing. So I would like you to enlighten us. What did the court order? You're saying it's a nullity, it should start all over afresh. What are you saying, State Counsel Haimbe?
Okay, and this is where it becomes imperative for us not to read words into a judgment. That's where we begin to have problems. When colleagues want to massage a judgment, clear words of the highest court, an apex court, that puts forward the decision that they have made. You cannot do that. You cannot put an interpretation of what you want them to have said in a judgment. Now, I'll go back, and we all know this, that the decision of the court is contained in the orders that it makes, in the reliefs that it grants. And I'll read again for the avoidance of any doubt, and I'll ask that our viewers are able to go to this judgment. It's available online. Simply look for the parties of the case. Type in your search engine, Munia Zulu and Celestine Mkandila versus the Attorney General, 2025 CC said 009, and you'll be able to follow. We must have the truth when we deal with these matters. And the court said this: accordingly, we grant the following relief, which I read earlier. We declare that the decision of the respondent to initiate a constitution amendment process before undertaking consultations is against the spirit. Okay, that's the first holding and finding and decision of the court. The second is we order that the respondent complies with the spirit of the constitution by ensuring a people-driven process led by an independent body of experts. Yes, it's there, so the people will follow it. Now, in those words, do you see anywhere that the court said start afresh? Nothing. In those words, do you see anywhere that the court said that this process was it is a nullity? There is nothing to that effect. In any of those holdings that I have read, does the court say that Bill 7 is now and void ab initio? It doesn't. It doesn't even declare it unconstitutional. And we have to look at this from the perspective of what those applicants asked. They asked, the petitioners asked for certain reliefs, which included the following, and I quote, a declaration that the decision of the respondent to undertake constitutional amendment process without undertaking wider consultation, etc., is in breach of the Constitution and thereby unconstitutional. Number 2, an order directing the respondent to undertake wider consultation with the citizens of Zambia prior to tabling of a constitutional amendment bill. And third, that the process be halted, amongst the various reliefs that they sought. Did the court grant any of these reliefs as put forward? The answer to that question is no. The court did not say halt the process. There is nowhere in that holding that the court said that. In fact, the court said undertake a process similar to that which was undertaken when President Sata appointed a technical committee. So what I am saying is, let's not read or embellish the judgment. The judgment gives clear directive that this is what must be done. The judgment, by the way, does not go further to say that do it in this particular form. It simply says that we must follow a process of wide consultation.
So looking at the screen and the judgment, State Counsel Sakwiba Sikota, again, for the sake of the public, you are both state counsels. What does it mean in 2? We order that the respondent complies with the spirit of the Constitution by ensuring a people-driven process led by an independent body. State Counsel Haimbe is saying the court never said the process should be halted.
Thank you very much. I think that the people of Zambia should realize that this is, how many pages long is this judgment?
The majority judgment is 25 pages.
25 pages. The 25 pages do not consist of only this, which is on the screen. The 25 pages give the reasons why they are making the judgment. They were not just sitting there, just filling up space. It has got a reason why it is that length. The 25 pages do contain this statement. Accordingly, we hold that the Constitution of Zambia, I can't quite give it to you offhand, but it's in the judgment. Accordingly, we hold that the Constitution of Zambia Amendment Bill number 7 of 2025 was not generated through a constitutionally compliant process and is therefore unconstitutional, invalid, and a nullity. That is in black and white in the judgment. And that is the reason they are giving as to why they are saying to the people of Zambia that the process did not meet the standard that is expected. That is in black and white. So it is those who wish to get round the reason of the judgment who will try to ignore that, who will say, no, don't bother about the other 24 pages. Let's just look at one page out of 25. That is not the way that you look at the law. The build up to that final declaration, the reasons are given. That's what judges do. That's why judgments are long. And that is what we must keep in mind.
State Counsel, just a rider, when the judgment is concluded, there is a ruling and an order. What did the court order? What did the court order the respondents to go and do?
No, what is important is what was the reason for the court action? What was the analysis of the court? And how did the court think, okay, we can have this matter resolved in this way? In the analysis, they find that it was unconstitutional, invalid, and a nullity. That is in the judgment. That is on their route to the final decision. They are taking that into consideration. So that means that that is the thoughts of the court. That is the thoughts of the court. They cannot put every single thing into the holding, but in the lead up to the holding, they'll give the reasons why they are getting there. And the reason very clearly is because it was unconstitutional, invalid, and a nullity.
Before we move to the contents of Bill 7, I really want us to, for the viewers and the listeners...
And I think that you've stolen my 20 seconds.
I'm still giving you more time. But yeah. the issue then is, the court made a decision. What we've seen now is a technical committee which has concluded its work and submitted a report. Do you still consider that an illegal body and an illegal process?
Well, on the issue of the technical committee, there is so much to be said about that and as to what is wrong. I'll give you an example. I think that they had a working space of just about slightly under a month, I believe. And the actual interaction with the general population was just slightly over a fortnight, I believe, so, or thereabouts. Now, if you look at even, and we're talking about the Constitution, if you look at even ordinary, just ordinary bills, the consultation that the committees in Parliament will give on ordinary bills, not constitutional bills, is at least 14 days before they tell, they'll even advertise. They've advertised for committee sittings which will be in January and so forth next year. And they're saying that make sure that you put in your submissions at least 14 days before the actual sitting. That's what they consider to be reasonable time for an ordinary bill. Keep in mind, that is for an ordinary bill. But for a constitutional bill, because of this mad rush, this indecent haste that they have, they're even giving less than what they give for an ordinary bill. That gives you a sense of the desperation, the sense of the way that they just are not bothered about the Zambian people.
Thank you so much. State Counsel Haimbe, the court ruled that the respondent needs to go back and do something that is in the spirit of the Constitution, in short, wider consultations. Is the technical committee a legal body, a legal process? Was this consultative process in the spirit of the Constitution?
Indeed, it was. It was in the spirit of our democracy to start with, because we also must speak of the wider context of what has been done. We have a situation where the executive said we want to do an amendment to deal with the non-contentious issues and comes up with a position in that regard. And citizens challenge that and they decide to go to court. And the court tells executive, you cannot do this. We say instead follow this process X, Y, and Z. Let us hail the democracy that the UPND government has brought. Because what does the government do, the executive do in response to that? It says we understand the separation of powers, therefore we shall follow what the Constitutional Court has declared. Very, very important. We contextualize these matters. And I will not leave the issue of the alleged decision of the court to declare the process a nullity. It is actually contrary to what the court itself said. The court was asked to do an interpretation. Yes, I said that we want to read into the judgment matters which are not there. But let us give the context of this decision that the court was making. The court was specifically asked to invoke the provisions of Article 128, which confer jurisdiction on the court. And in doing so, it said that we will not confine ourselves to the provisions of the Constitution per se, which was in terms of Article 79, the process that was invoked for the amendment process. The court went back and said, let's look at the initiation of the process pursuant to our power under 128C. Therefore, the court did not look at, by the way, this action commenced prior even to Bill 7 being tabled. So to suggest that the court addressed its mind to an issue that did not exist at the time that the matter was commenced is being a little bit mischievous. But specifically, the court said, we will look at the initiation process. We will look at how this whole thing was started. That's where we will confine ourselves. And the decision that was made did not speak in any way, form, or shape to the provisions of Bill 7, because it was not in the contemplation of the court. The court, in all its substantive reasoning, spoke about the initiation process. How did this whole thing start? Very, very crucial. And the court then goes and says, we would want you to follow as much as possible the process that was undertaken under the TCDZC process. That is the Technical Committee on the Drafting of the Zambian Constitution, appointed by President Michael Sata in 2011. That was done through a technical committee process where the president invoked his powers under Article 44 and 33 of the Zambian Constitution as it then read. Currently, the technical committee was appointed by President Hakainde Hichilema pursuant to his powers under Article 92 of the Constitution, and in particular, there is, I think, sub-article F, 92F, I believe. But we can go to those details. Those provisions are mirror images of each other. So if there is a precedent that existed when President Michael Sata appointed the TCDZC, that precedent has been declared, in fact, lawful by the Constitutional Court. And therefore, the same process that was followed by President Hichilema is lawful.
In conclusion, was Article 79 of our Constitution violated in this process?
No. Not in any sense. As I said earlier, the court did not even speak to the issues of Bill 7 itself. The question that was raised is, can this process be undertaken in the way that it has been commenced by government? Amongst the questions that were being asked by the executive. And the court said, we have a general power under Article 128C to inquire into the actions and decisions that are taken. So it did not even refer specifically to the provisions of Article 79 per se in determining that this matter must be concluded in this way. It looked at how the process was initiated and said the precedent we have in this country is that we have commissions, we have other modes by which these processes of consultation must be undertaken, and then said, government, you must do this in substantial conformity with what President Michael Sata did.
You want to rebuttal?
Yes,
very quickly. I'm giving you 30 seconds.
Certainly. You'll give me 1 minute.
I need to get to my viewers on Zoom as well.
But you still have to balance.
Please.
You still have to balance out. I should not be the one suffering because you have to get there. It has to be balanced.
Go ahead.
Thank you. Now, what is very, very clear is that the whole Munya Zulu matter was about Bill 7. Everybody knows that. Everybody knows that that is what it was about. And you cannot talk about that, oh, they were talking about how the process was initiated. What process? Process of what? Process of Bill 7. Nothing else. So let us stick to the truth. And I think that we must be careful that just like Justin Mulenga was warning in the introduction that he made, when he said that it should not just be about legal provisions. He said that. Again, I'm quoting what he was saying. And what we must look at is, let's sit down and say, what was Munya Zulu and Mukandile asking? They were saying that this process of this new bill you're trying to introduce is wrong. Which is that bill? That is Bill number 7. That is what was being taken to the courts. And we must never forget that. And we must not try to use flowery legal language to try to confuse the ordinary person. The ordinary person has to follow what is going, what is being said and what is going on. That is very important in that what we must be doing, apart from making sure that we are following the legal provisions, is again, do what Justin Mulenga was saying, that every reform we do must be done with trust. You can only do that if you do not speak over the heads of people, but you actually talk to them and do engage with them. That is the only way to do it. And that is what must be done. And unfortunately, that is what this government is not doing.
I've given you enough time. I hope I'm being fair on that.
You haven't given me enough time.
Well, my director says
if you look at the timings, you'll see that you haven't. And please change that attitude that you must be balanced. The other one was 1 minute 30. With me, even with this extra talking, is 47.
Remember, I'd given 3 minutes to wind up on this for either of you, so you were free to jump into it. We are trying to be as balanced as possible. Before we move to the substantive content contained within the bill and the technical committee report, allow me just to bring via Zoom one of the petitioners in this particular case and judgment that we're discussing, Celestine Mukandila. For you, you've got just a minute and a half to give your contribution, Counsel Mukandila. Very quickly, your submission in 90 seconds.
Thanks very much. Thanks very much, Costa, and thanks very much to the panelists. And I think it's extremely. Can you hear me? Yeah. So I think it's extremely important. I think it's extremely important at this point to stress a point which is within the judgment. And at this point, I would want State Counsel Haimbe to direct his sight to page J23 of the judgment, which is very categorical. Paragraph 51 states that, in our considered view, the TCDZC process should be replicated or something of similar magnitude, pursued in initiating constitution amendments. It constitutes what we understand to be wide consultative process necessary to alter the existing content of the Constitution. State actors should be facilitators of the people-driven process led by an independent committee of experts which collects views directly from the people, and existing records. And it goes on to say, only after proposals are put to the people in a structured manner, such as through district, provincial, and national level discussions, and adoption can be put through the process in Article 79 of the Constitution. I think that the judgment is categorically clear. It requests you, State Counsel Haimbe, as the state, to ensure that you replicate the process that was undertaken by the technical committee on drafting the Zambian constitution. And that process required that one, create an independent commission appointed by or using the Inquiries Act, because that is a replication. It does not provide that you appoint a committee using Article 92 2F as was used by President Hakainde. I think let's be very honest when you're looking at the judgment. Can you hear me?
Unfortunately, but I'll still make you stay on the line for Counsel Haimbe to quickly respond, because he seems to be nodding or shaking his head.
I'm laughing actually.
So when you look at the ratio
your time is up, Counsel Mukandila. Thank you so much. You can respond, State Counsel.
I'm actually laughing, Costa, because now we are grasping at straws and telling the nation complete untruths. And by the way, Costa, I hope you'll be able to bring the respondent, who is the Attorney General, as you've done bringing the petitioner Celestine Mukandila on this program. I hope Attorney General's chambers are ready and will be brought on the show. Now, that is a complete lie, and I'm happy to use that word. I know it may sound a little bit harsh, but what the Counsel has just mentioned is a complete lie, suggesting that the technical committee for the drafting of the Zambian constitution, which was appointed by President Sata, was by way of a commission of inquiry. That is a complete and total misnomer. That is a lie. The commission of the technical committee on the drafting of the Zambian constitution was actually appointed pursuant pursuant to Article 33 of the 1996 Constitution, as laymen call it, but it was actually an amendment, and also Article 44 of that Constitution. And those provisions, and this can be checked, by the way, it's a historical fact, in the report of that commission, which was rendered in 2012, I believe, or 2013, it actually says our appointment was pursuant to this provision of the law, not the Inquiries Act. And by the way, the terms of reference are here available. We can go into them if they should so wish, of the two committees that were appointed under the two presidents. Now, let me go to the 1996 Constitution, which, pursuant to which the Technical Committee in 2011 was appointed. It provides in Article 44 the powers, the functions of the president, and it's quite long. But amongst them, it goes under Article 44, sub-Article 2, without prejudice to the generality of Clause 1, which gives the president certain powers. There are other powers that it confers on the president, including to appoint such persons as are required by this constitution or any law to be appointed by him. In the same spirit and in the same letter of the law, in Article 92 of the 2016 Constitution, there are similar provisions which were used. And I read, and I quote in particular, it's very important that the people understand this, to appoint persons as are required to perform special duties for the executive. That's Article 92, sub-Article 2F. Now, I need to be very clear. Here I have been quoting specific provisions that can be confirmed. Nobody else has done that. And your petitioner who you brought has not cited that part of the judgment, which it is claimed.
He was quoting paragraph 51 of page J23. You have the judgment. We'll be getting back to that. Yes. State Counsel, what is your Sakwiba Sikota, what are your observations or comments on what the petitioner has just said, and in view of this discussion on whether that part of the judgment on page J23, paragraph 51, what was supposed to happen if we're to go back to a similar process like the Michael Sata, commission, and State Counsel Haimbe has given his thought on what should have happened.
No, thank you very much. The petitioner happens to actually even be a lawyer. He's a lawyer, actually. And he knows exactly what they had gone to court for. He was intimately involved with the case. So he is not just talking from without. He's actually talking, having been there from day one, minute one, to the last minute of the case. And he heard everything. And what is at J23, para 51, is something which really is supposed to have been looked at by the people who were doing this new attempt. And it is very clear that what was needed, firstly, was an independent set of experts who would look at it, genuinely look at it, not just be there for show. Because when you look at the time that they were even given, it was for show. When you look at the fact that they were not given a free hand, but they were given a set of rules as to what they are to look at, which was which was Bill 7, shows that it was all for show. That shows the extreme bad faith with which they approached the matter. You do not go around seeking to say, how do we get past that requirement, that judgment? Oh, let's put up a show. The Constitution should not be dealt with that way. It should be dealt with honestly and openly. This is what this government has failed to do. My colleague talked about that they earlier on had wanted to have a holistic review of the Constitution, and then they decided, oh no, let us perhaps just look at the non-contentious issues. I think that quite clearly they were not right in what is non-contentious. If it was indeed non-contentious, we would not have a situation where even your own Justin Mulenga has declared that, and he's an independent person. I believe that Diamond TV is independent. I believe so. An independent person has said that this is the most contested. You cannot say that then it is non-contentious issues. And who is it who decided that these are the non-contentious issues? This was fixed from day one, and the Zambian people do not want to be part of a rigged system.
So we'll be getting now into the contents, but I just want to clear one thing with you, State Counsel Sakwiba Sikota. Is the appointment of the technical committee that just submitted a report, is it illegal, or is it not in the spirit of what the court ordered to say they need to go back, according to page J23, paragraph 51, and select an independent? Are they not independent? Under 12,000 submissions, isn't that wide consultation enough? When you say they are being rushed, does the Constitution give a specific time frame in which a technical committee is supposed to work?
Let me start with the last bit about being rushed. The whole point of having consultation is to give people enough time to be able to consider what you are asking them about, and for them to then give you a feedback. That clip you had of people off the streets clearly shows that the majority of them don't even know what is being talked about. That means that you have not given sufficient time. And you're talking about people in a very urbanized situation. My colleague said that, in fact, most of them are from Lusaka Central. Those are people, generally, when you look at the population there, have got good communication and everything. You're not talking of my great uncle in Kalabo or somebody in Kaputa or Shangombo who most probably has never even heard that there's Bill 7 going on. So you have not gone in the spirit of it. The spirit of it is to gather a true reflection of what the people say. The spirit of it is not to drive people in a certain direction. It's to give them sufficient time. This is,
for the sake of time, is the technical committee an illegality?
It is an illegality because it is not independent and doing it in the spirit of what the court said it should do. It would only be illegal if it was independent and doing it in the spirit that the court said it should do. By not being in the spirit, that makes it illegal.
Unfortunately, we need to move because there's so much ground to cover and time is not with us.
Yes, Costa, but you did give State Counsel quite a bit of time to speak to this issue.
I know you.
I think I'm entitled
I gave you enough time to respond to Celestine Mukandila.
Yeah, but I'm now responding to State Counsel. It brought different dimensions that I must speak to.
I will. Unfortunately, we need to move to the contents of the bill, if you allow me, State Counsel. And in your time, you can find probably some space to respond. Let's get into the substantive content contained within the bill and the technical committee report. And I want to start with an issue, whether it's contentious or non-contentious. State Counsel Haimbe, critics argue that introducing a mixed member proportional representation system is a step backwards because legislators should be elected directly by citizens, not appointed through party lists. What is the justification for introducing this model?
Thank you very much.
So I'll give you 2 minutes for
this. Yes, I'll speak to that. And let's go by this one super citizen, Justin Mlenga, who appeared in your video, who suddenly has become the be-all and see-all of Zambians' opinion on what is contained in Bill 7 and our constitutional making process. We completely forget here that the trade union has spoken in favor of Bill 7 and on behalf of thousands, perhaps millions of Zambians. The students have spoken in favor of Bill 7. This is on record. I don't know how come Justin becomes the one that is the epitome of our conversation regarding Bill 7. It's not a realistic position to take. Justin is but one person in a video that was taken. We don't even know the process that was undertaken. I'm not saying anything about Diamond TV, but that is my view. I wanted to put that across because it seems that Justin has been put in all this and has become what is the essence of Bill 7. People have spoken. The chiefs have spoken who represent the people. And by the way, even when we talk about going to Shangombo and so on and so forth, in actual fact, the technical committee went to all the provinces of this republic. How much more inclusive of a process do you want to be undertaken? The question you've asked repeatedly as to whether or not it was illegal, the technical committee, has been answered very vaguely. I have cited specific provisions of the Constitution and the previous Constitution which were used to appoint these technical committees, and it is sound in law. You cannot simply say that it's illegal because it's not following the spirit. That is precise. That being said, to answer your question on going backward, I shudder to wonder how introducing provisions that allow for these vulnerable, ostracized people in our communities to have a voice means going backwards. It's unfathomable completely. All this time, civil society, the opposition, were talking about the fact that this UPND cabinet has got only 3 women, 4 women, or whatever it is. It's not representative. All this time, we have spoken as politicians that it's difficult for women to use the ordinary path of direct election. I'm using women as an example of direct election because of the abusive nature of our political system. And we come up with an idea that would give these marginalized groups an opportunity to participate effectively. And someone says it's going backward? How? In what sense? It's not possible. In fact, it is a progressive provision that says, let us embrace the youth, because those were also said not to be given enough opportunity to participate in governance. This mixed member proportional representation system that we are proposing in the proposed amendment clearly incorporates these groups. It brings them together, gives them an opportunity that they would not otherwise have when you use the ordinary method of election. And that, by the way, is not to say that they will not participate in the other process as well. So they have, we know that we've got a diverse crowd, double to use that expression. The ability to be brought into parliament via the list system using the mixed member proportional representation, but also directly they can compete and participate. Where are we going backwards in that regard? There's no way.
Thank you. State Counsel Sakwiba Sikota, your take on mixed member representation. Do you support the issue of a small parliament as proposed under Bill 7, a smaller parliament?
Thank you very much. I would like to start off by saying that there is an Official Oaths Act, which is Cap 5 of the laws of Zambia, which sets out the oaths that people take. The Official Oaths Act for oath of office says, I will well and truly serve the Republic and the President of Zambia, that I will be faithful and bear true allegiance to the President and the Republic of Zambia, that, and this is the most important part, I will preserve, protect, and defend the Constitution of Zambia as by law established. That oath is not only there for that, even for the judicial officers, it has similar wording. It says, I will do justice in accordance with the Constitution of Zambia as by law established, and in accordance with the laws of Zambia, without fear, favor, or ill will. As a lawyer, all lawyers, when being called to the bar, also take an oath to defend and protect the Constitution. And it is not only us. Mr. President, let me remind you of the oath that you took. President Hakainde, you took this oath. I, Hakainde Hichilema, having been constitutionally elected to the office of President of the Republic of Zambia, do swear that I will faithfully and diligently discharge my duties and perform my functions in this high office, that I will uphold and maintain the Constitution and laws of Zambia, and that I will dedicate my abilities to the service and welfare of the people of Zambia without fear, favor, or ill will. Having taken that oath, Mr. President, you need to ensure that the Munia Zulu judgment and what was in it is followed by yourself. I, as a lawyer, having also taken that oath, have to ensure that I protect the Constitution by abiding by what the Constitutional Court said, namely that this Bill 7 is a nullity and illegal.
You decided not to answer the question of mixed member proportional representation in your 2 minutes. I believe you have nothing to say about it.
No, I have lots to say, If you allow me, I will.
You say I'm unfair, but I gave you the 2 minutes.
No, but the assumption is what I am saying is not correct. When you say that, you assume I have nothing to say. I say, no, I've got a lot to say.
Great.
That is not a fair assumption to make.
No, I stand corrected. Let's continue, because now we've gone into the content of this bill. State Counsel Haimbe, Article 58(4) of our Constitution states that the Electoral Commission shall determine the names and boundaries of constituencies and wards, and Section 5 of Article 59 states that the Electoral Commission shall, at intervals of not more than 10 years, review the names and boundaries of constituencies and wards. The issue of delimitation, again, is coming up, and we saw the Electoral Commission of Zambia appear before the Select Committee at Parliament, using the 2019 report as a basis and saying this report has now been revised in 2025. The question is, again, the transparency and openness of this delimitation. Where is the revised report of 2025, and where are we drawing the mandate to propose delimitation in Bill 7 of 2025?
Yes, thank you, Costa. Delimitation is one of those issues which our people have repeatedly spoken to, and it is something that certainly they want. And I'll go into the meat of why the substance of that particular provision. Let me say, make an overarching comment regarding the content of Bill 7. These are 13 articles that proposed amendments to the Constitution, not a reworking of the Constitution as a whole, but specific proposed articles 13 as contained in that Bill 7. And each of them speak to an important facet of our governance, including what you've spoken about, delimitation, including the removal of the provisions in Article 52, which were somewhat ludicrous, including speaking specifically to the question of how do we hear and determine an presidential electoral petition. Those are all matters we have spoken about as Zambians without question and without doubt, including as long ago as the earlier Constitutional Review Commission. So we cannot come today and suggest that these matters have been plucked out of the sky. That is, again, not being in touch with the reality that we are faced with as a people. Now, let's talk about delimitation. You've asked about where does this requirement, where does this drive for us come from when we speak about the need for delimitation? And you've quoted the appropriate articles, and I'll go to the Constitution. I've got all three of them here, or is it four, as the case may be, I don't know at this point, where in Article 58 delimitation is spoken about, and you quoted some of the words. The important thing to note there is that a time limit is given as to when delimitation must occur. It is clearly stated in Article 58 that the Electoral Commission shall undertake this process at least every 10 years, in a cycle of 10 years. So where we are now is a necessity. Otherwise, you are saying that you want us to commit a constitutional breach by not having that delimitation, because the last one, of course, only took place more than 10 years or plus or so ago. So it is a requirement. Now, you have asked a question about how this delimitation is undertaken. And I would like to draw the attention of the public, because it's been suggested that it's an arbitrary process. You've actually suggested that yourself. Article 59 provides safeguards in the Constitution itself of how this delimitation must be undertaken, and it gives criteria which must be taken into consideration to take into the account the history, diversity and cohesiveness of a constituency, to have regard to the population density trends and projections, C, to ensure that the number of inhabitants is reasonable in terms of the geographic features. I'm rushing through because of time. Ensure that constituencies, wards are wholly within districts, to achieve, very importantly, an approximate equality of constituencies and ward population, subject to the need to ensure adequate representation for urban and sparsely populated areas. This is the criteria that the ECZ uses in order to determine how delimitation will be undertaken. And a failure to comply with this is a constitutional breach which is actionable by anybody who is not happy with how the ECZ has undertaken its exercise. It is there in the Constitution. Nobody would dream up constituencies and say that it is because of some other consideration outside of the Constitution. We look at population, we look at the size in terms of geographic significance of a particular constituency and determine. When I say we, I'm talking about the law. That is how ECZ decides the issue.
Thank you so much. State Counsel Sakwiba Sikota, Article 58(7) of our Constitution provides that even a report such as the one for delimitation by the ECZ can be challenged before, the courts of law. I want your take on this issue of delimitation and its proposition. Why is there all this skepticism that when State Counsel Haimbe says it is law, it is constitutional, every 10 years we must delimitate, and the time is now? Why then are we thinking that this is a political gimmick by the party in power, that delimitation advantages them? Isn't it a constitutional requirement? Your 2 minutes.
A simple answer, it is a gimmick. It's not that we are thinking, it is a gimmick. The law with regards to delimitation, yes, says that every 10 years there must be a delimitation exercise undertaken. Now, delimitation, what is it? Delimitation is what my colleague referred to, making sure that you look at how changes of population have happened, whether there's been a lot of movement of people into a certain constituency, so that now it's overblown, or that so many people have moved from this constituency that there's not enough people in there. So you remedy that. The remedy, and nowhere does it say in the law, nowhere does it say that the remedy is to increase the number of constituencies. That is not there. The remedy is that you redraw the lines. Redrawing the lines does not mean increasing. You may increase, yes, but it does not mean increasing. And nowhere does it say increasing. So let's say, for example, you've got constituency A, which is next to constituency B. And a lot of people have moved from constituency A into constituency B. Then what you could do is maybe enlarge the size of constituency A, so that some of those people who have physically moved into what was then constituency B are now within the same area, so that you're then still striking the balance in terms of the numbers of people. And if this was being done honestly and not a gimmick, that 2019 report is what would have been the one they're following. When was the new report made? Where is this mystery new report? It's being kept like it's some kind of secret cult document. Government should not be run like a secret cult. No. This is not a cult. Zambia is not a cult. These things should be out in the open. Which constituencies right now are the new 55 that they are looking at? Where are they? Why have the people not been told? The minister is here. Perhaps he will be good enough to tell us where these 55 are. And if he's not going to tell us, perhaps he will be good enough to tell us why they're keeping it secret, like it's a cult, that they should be the ones to know. They expect Zambian people to say, yes, increase the number, without knowing where the increases are being done. I will tell you, anyway, I'll use my next section to move into that to expand.
If you may allow me, you've challenged him. You've asked him some questions.
Yes,
can we allow him 30 seconds to answer your questions?
Yes, specifically.
30 seconds, Counsel Haimbe, to answer.
Thank you very much. State Counsel, you cannot put the cart before the horse. Before it is determined that there will be 51 additional constituencies, you want those constituencies to be identified? How? It must follow a logical sequence. The constitution amendment is done. We know that we are increasing the number of constituencies to X, and then you say, given this number that we've been given to work with in the constitution, this is how it is going to be done. It is a matter of simple logic. And I would like to also then attend to the issue of some of the concerns that have been put across by State Counsel in suggesting that this delimitation does not necessarily mean increasing the number of constituencies. Let us give a practical example. If you look at Eswatini, a country in its entirety, the total square meters of Eswatini is 17,364. Now let me give you one constituency. In Kampiriposhi, we've got 17,219 square meters. If you do not divide that constituency, how else are you going to stop a country being a constituency? Katombora is 18,055.
Thank you so much.
I'll keep on, I've got the statistics.
Thank you so much.
From facts, not speculation.
Allow me now to bring via Zoom the board chairperson of the Gears Initiative, Zambia, Mr. Lakson Lungu, who's going to make a contribution. Mr. Lungu, good evening and welcome to this discussion. 90 seconds for your contribution, very quickly.
Good evening. Thank you so very much, Costa. Good evening to State Counsel Sakwiba Sikota. Good evening to State Counsel Mulambo Haimbe. Thank you so very much for having me on this very important discussion. Thank you so much for having me on this very important discussion. I'm enjoying the debate, very healthy debate. Now, as Gears, I think you are aware that we have been on this particular debate for quite some time. We have been supporting the constitutional amendment, I think, from the time we started calling for it. To start with, let me indicate that we as Gears Initiative have been on record of having been calling for constitutional amendment from the time the UPND came in power. And we are calling for constitutional amendment based on the fact that one of the promises the government, the UPND party then made, was that they are going to embark on constitutional reform immediately they form government. And Honorable Haimbe would agree with me that when he was Minister of Justice, he indicated to the nation that indeed the government was ready to commence constitutional amendment processes. So we have been calling for this process for quite some time. And we're excited when finally the president indicated that the constitutional amendment process is now ready to commence. So we got excited as Gears, and we waited to see which areas. Of course, we had our own areas that needed constitutional amendment. So when the areas were brought, we already thought as an organization that now we are going to see what next steps are going to be taken. When the roadmap was introduced, we worked with other civil society organizations to engage the Minister of Justice now in terms of how exactly we wished the constitutional amendment process was to be undertaken. And we had the concern when it came to the production of the bill. When the bill was finally introduced.
Mr. Lakson Lungu, thank you so much. Your 90 seconds is up. We are having limited time here. I'll now go to Mr. Malila Melusi, a lawyer as well, to quickly make his contributions and observations in the next 90 seconds. Counsel, you can go through with your contribution in 90 seconds.
Okay. Thank you, Costa, and good evening to the two state councils, state council there, and thank you for this opportunity. My small take on this, my small contribution is that I agree with State Counsel Mulambo Haimbe on his reading of the Celestine Mukandila judgment, though I do not agree with his conclusion, but I think the issue was about the initiation of the constitutional amendment. And at the time, as he rightly put it, Bill 7 was not yet there when the court gave its decision. So the decision of the court was to the effect that the process which the government was using to start the process, so it's all about the start, was against the spirit of the Constitution. Maybe it would benefit the Zambian people to ask the two state council over there what they understand by the meaning of the words against the spirit of the Constitution at initiation. My understanding is that the judgment was all about the start. So what the court said was that the start was against the spirit of the Constitution. And in my understanding, it means that the starting of the process was against constitutional principles, which means that everything has to do with the start, with how the process was started. That's my contribution to this debate. And I thought you could redirect, because I thought it wasn't adequately covered by the two state council as to what they understand by one, the initiation of the process, and also what it means by saying that the initiation of the process was against the spirit of the Constitution. Thank you.
Thank you so much for your contribution. Counsel Sakwiba Sikota, I'll come to you. We're now cruising very quickly around the contents. You've heard the two contributions from Gears and from Counsel Melulu Malisa. I want to move to the issue of reserved seats for women, youth and persons with disabilities. Bill 7 is proposing allocation of 3 seats for persons with disabilities compared to the Technical Committee's recommendation of 12. Why reduce representation for one of the most marginalized groups? What is your take on this? Is there any concrete proposal that you may have on this matter? And probably in 2 minutes, your observational responses to the callers.
Thank you very much. I think that before I get into that, what Counsel Malila said is quite important. And I think that what you have to look at is the initiation process, yes. And they tried to reinitiate by bringing in this technical committee. But when you reinitiate, it means that that which had happened before, which the court said was not right initiation, is thrown away. So you cannot build on something which is not there, like Lord Denning said. I'm mindful of the time. Let me quickly answer one or two issues that were raised by my colleague, who said that look at Eswatini and the number of voters and the size of the place. Look at the US. They've got roughly 450 House of Representative members. Their population, 300 million. When is the last time that they did a change in increase in number? It was at the beginning of last century when there was a small increase in the number. So if you're looking at figures, you can pick Eswatini, but you also have to look at the US and see that the two would cancel each other out. He also mentioned that the unions, and he says the students, have talked on this and said, oh, that's lots of people. But those who have talked against, just the churches alone, put together the unions and the students, the churches far outstrip the number of people represented in Zambia. There's nobody, not even any party, which has got more than the churches. So the churches have said, no, this is all wrong. He mentioned the chiefs. The chiefs, a good number of them, recently His Royal Highness Mwata Kazembe said, no, we haven't given us enough time. That is the chiefs that he's talking about. They themselves have said, you haven't given us enough time.
Your 2 minutes, Counsel Haimbe.
Thank you so much. I think the important thing is that clearly there is an admission that these groups actually had the opportunity to speak to the issues of the Constitution. That is what is required. That is the democratic process that we've been talking about. And that's the process that the court also referred to. Now, there is a specific aspect that was mentioned in the two clips that you brought before us a short while ago. And one of them was in relation to the initiation question. And I'm grateful for Counsel Malulu for saying that actually what I've said with regard to the provisions or the findings in the Celestine Munyandela case are to the effect that I mentioned. Now, let us look at the process of amendment holistically. Again, we can't take things in little snippets and say this is the direction that the court has said we must go. As I mentioned earlier, the court did not give any prescription. It did not prescribe that in following substantially the process that was undertaken by the previous technical committee, you must do X, Y, and Z. The court simply stated, and it gave direction, which we have followed as government magnanimously, that you must adopt this process. This is why you have seen the technical committee coming in. Now let's go into technical language here. When you talk about initiation for the amendment process, there are 4 steps according to the parliamentary procedures, the standing orders that must be followed. First reading, second reading, third reading, and the committee stage. Each of these are part of the process of enacting law. Now, when you talk about initiation from the perspective of parliamentary process, the only step that was taken was what we call first reading. And if you read the standing orders, first reading is described as simply introducing that piece of legislation that you intend to enact. The other processes then follow after introduction. In this case, what happened? The government, upon realizing that the people had complained about the process, when President Hakainde Hichilema met the civil society, halted the whole process. So it stopped at initiation, right there, at a process of introduction. No other step was taken. I'll build up on that.
Thank you so much. Counsel Sakwiba Sikota, Bill 7 removes by-elections for seats held by political parties in an event of death or resignation. What is your take? How does abolishing by-elections strengthen democracy?
Thank you. The last comment by my colleague cannot go without a response. It is an admission by him that the process had started. Whether it was stopped or not, it had been initiated. Once you take the bill for first reading, it means you have started it. You haven't brought nothing. You have brought something. And that is what was said to be wrong. The initiation was wrong. That means that which you brought falls away. You cannot say, okay, we'll hold on, try to fix things and come back again to continue this which was wrong. It is wrong, it is dead, you cannot bring it back. You cannot bring a cat which died on 27th June back on 8th December and expect it to be a healthy introduction of something. And then there was also his statement that these people had an opportunity to talk. All of them, the ones I mentioned, said, you have not given enough time. Yes, they came and said, hey, yes, we've come to tell you basically that you have not given us enough time to consider this. That is what they said. But this government did not listen. It still went ahead because it had already a fixed idea of what it wanted to do. And then earlier on, there was the issue of what other reason would they have for introducing new constituencies. We do know that quite a number of the UPND current MPs know that they are not going to make it this time round. So they will look around and try to find where they consider it safe to produce new constituencies so that their people can move there and be safe. If you look at Lusaka, for example, most of the UPND members will not come back.
Your 2 minutes is done. Counsel Haimbe, by-elections. There is this proposal that we are spending so much money in terms of these unwarranted by-elections. But then from a constitutional point of view, and I say this in terms of we have a system of democracy where people vote and elect leaders of their choice. Won't this decision take away the right, the franchise of people to vote for a candidate that they want, where we're now giving the power to a political party? Some are also arguing that then you simply have stooges where the appointing authority says, Mulambo Haimbe, we don't like you in Lusaka Central, we're removing you, we're picking somebody else from the party. Is this not undemocratic, unconstitutional?
Thank you, Costa. I mean, that's the point of view which others might take with regard to by-elections. But the fact is that we have all spoken, all of us as citizens who are logical in their approach to things, that by-elections are a drain on our resources as a people. Let's do away with them. Now, this is why this whole conversation is very important. It's part of the amendment process. If those who take a contrary view on the floor of the House or even during the submissions to the Select Committee brought that to the Select Committee to be part of the report of the Select Committee, who recommend that no, let's do away with the issue of saying we'd go by party list. And of course, Parliament itself would decide. That is the whole essence. You can't argue about something before it has happened outside using speculation speculation. Just now there has been speculation to the effect that most of us UPND MPs will not make it back. Really? Where is that coming from? Which opposition is going to remove us, first of all? Because it's non-existent, it's dead. The opposition is unable to offer a response to this government of the good things that we have done. So that is speculation. Now let us talk about the realities. The suggestion that is maybe we're going to do this delimitation in constituencies that are in the strongholds. But the facts themselves will speak. I had started with a list of some of the biggest constituencies we have in this country. We have Kapirimposhi, we have Katombora, we have Mufumbwe, we have Kanchivia, 8,800 square kilometers. It's bigger than the entire country of Luxembourg in Europe. That's one constituency. Look at Lumezi, 9,776 square kilometers. I can go on and on and on. The fact of the matter is that this is one parameter of the need for delimitation. The fact that we have too many constituencies that are the sizes of countries and beyond. So if I talk about, we compare equity, Lusaka Central, I'm able in one ward, Luwa ward, to build 4 police stations or rehabilitate them. It means that my colleague who is in Kapirimposhi with 17,000 square kilometers, if he builds 4 police stations, it's akin to saying that in the whole Eswatini, which is the size of this Kapirimposhi, they have only got 4 police stations that they've built under CDF. Is that fair? Let's be logical and truthful to ourselves. Why we need to do these things.
The time is up. Before I move on to the next issue of MPs sitting in councils, let's just quickly touch on something to do with delimitation. It also talks about population. State Counsel Sakwiba Sikota, he's giving examples of the square kilometers and these sizes. How would you marry the rationale behind delimitating constituencies by size versus, population? And Counsel Haimbe, I think you still did not answer the question. You were accused of hiding the report. This revised report. He wanted you to respond, to say, where is this?
There's no secrecy in any of the processes. I said that the only way you will understand delimitation and the actual delimitation that will take place is when you know what you're dealing with, meaning that ECZ's preliminary report cannot be taken as the basis upon which delimitation will be done. When the constitution is amended and it is said that we'll add 10 constituencies, ECZ will come back and say, our proposal is it will be these 10. That's what I'm saying. That is no secret. The law actually provides that ECZ can be challenged. You quoted that provision. How else can ECZ be challenged?
Are you hiding the report?
No. It's not being hidden. It's there. It's available. It's there to be seen by everybody. This is the narrative that keeps being pushed. But there's no facts to prove that there's hiding of the report. Is there a letter that has been produced to say, as this particular grouping, WOZA, we have written to ECZ and requested the report. This is the response from ECZ. This is how we should speak from an empirical fact. Whether the report has been published or not, that is for ECZ to respond to, okay? That you can ask ECZ to do so if you so wish. Then you would be able to have a factual basis of saying ECZ has refused and is hiding the report. Outside of that, it's speculation.
Let me allow him as well to...
It's speculation.
To be fair, let me allow him as well.
Yes, please. On the ECZ issue of the report, ECZ themselves have said, we have given the report to government. So government are the ones who should give it to you. That has been stated by ECZ themselves. The people who are hiding it are the government. They're hiding it. If they were not hiding it, you'd say, no, it's out there in the public. You can find it on websites such and so on, but there's no such thing. It is untruthful to say that it is out there for the people to see. That is a lie. And then also to state that it is only after you've said how many constituencies that you can then say, okay, the ones are these and these. On what basis did you arrive at the figure of 55? Don't tell me you just dreamt up 55. That's not reasonable. You must have arrived at it by looking at certain things and saying, oh yeah, this one will need to be cut up or whatever. You don't just dream up a figure. That is unreasonable.
Let's move to some of the other provisions in this bill. Again, before the 2016 amendment number 2, we had members of parliament sitting in the councils. We changed that. We now want this back. Let me begin with you, State Counsel. Are you in support of this? If not, what is the alternative model for this?
I think that on the issue of MPs sitting in the council, I think that should be left to debate on the floor. It should be left to more wider consultation with the people of Zambia, not this process where people, and most of them don't even know what is in there. I think that with that, us as Woza will go with whatever the people genuinely will say they want with regards to that. What is important is to listen to the people of Zambia, give them ample opportunity to give their reasons. You know that this report is 174 pages. 174 pages. And you know that the average time for somebody to be able to read a page, A4 page, is about 1.5 to 2 minutes. That means that to read 174 pages, you would need continuously 4.5 hours to 7.25 hours to read. I don't think that cabinet ever met to consider that report. And that those who, if they did meet, it must have been a very small kitchen cabinet, and that they would have had time to really put into proper perspective what is in that 174-page report. The fact that the very next day they were passing it on means that they were just waiting for it to come. Even before the ink had dried on those pages, they were handing it over to say, now take action. They had no time at all to go through those 174 pages and really properly look at it. That's how bad this whole process is. The indecent haste is frightening.
Thank you. My director tells me we only have 6 minutes to close the program. So what I will do, starting with you, State Counsel Haimbe, I'll give you 3 minutes to basically close on any area of this matter, because we still have lots of issues, ministers outside of Parliament, Articles 52.6. Director, show him 3 minutes. I'll give you 3 minutes to wind up, then State Counsel Sakwiba Sikota 3 minutes as well to close. So your 3 minutes, State Counsel Haimbe, starting now.
Thank you very much, Costa, and again, thank you to everybody. I want to touch on one or two things. There was a comparison of the U.S. House of Congress being 450 compared to us who are trying to increase with our small population. But that's akin to saying that Zambia and the U.S. can be compared like oranges, like for like. We forget that the U.S. is way more developed than we are, and therefore have got different means by which they can ensure effective representation of the people. You can't compare apples and oranges. Again, that's an inappropriate way of looking at things. There is no lie that has been spoken here. There is no report that is hidden or secret. That is speculation. And to suggest that perhaps Cabinet did not have opportunity to read the report, again, is pure speculation, because unlike our colleagues who served in the past, I hate to bring them up, we work. We do not sleep. We read those reports, and our President Hakainde Hichilema is clear in what he expects us to deliver as Cabinet. You do not take a laissez-faire approach, and you can see even from the manner of my debate the nature of research that I have done to respond to these questions. Up to this point in the program, we have not been shown a provision which has said that in fact the judgment of in Celestine Mukandila said there was a nullity. Zero. Nothing has been brought to the people of Zambia, whereas I have been able to cite the clear provisions of the law and of the facts that I'm relying on. At the end of the day, the people of Zambia can see that this process is a genuine process which is aimed at achieving outcomes that enhance our democracy, that enhance our participation, enhance the participation of marginalized groups, the women, the disabled, and the youth. These are cries that the people have been having. Talking about coming back into the council, it is not just on a whimsical approach that we are saying that MPs must come back in the council. You will see, for example, that the implementation of enhanced CDF has got the local authority playing the key role in doing so. We as MPs sit outside and are not able to provide even a supervisory role, and yet we take the accountability. Going back in the council is to ensure a smooth process between the various entities that are working towards achieving our enhanced CDF. So all in all, you can see that there is clearly, substantively, in Bill 7, lots of benefits. Nothing has been pointed out here which is contrary to the will of the people of Zambia. Nothing has been pointed out here which talks about governance issues, which talks about all these allegations that have been made. You can purely see that the bill is for practical purposes to ensure that, as I said earlier, wider representation on the part of the people of Zambia. In terms of the alleged illegality, I have shown distinctively here that the standing orders of Parliament provide in Standing Order 122 that introduction is by first reading. The substantive steps of amending have actually now taken hold after the technical committee has provided its report. What does it mean? The technical committee's input is going into the amendment process, meaning what goes on the floor of the House for decision by MPs has been sanctioned by the technical committee or otherwise, depending on what they stated, meaning that this process is not illegal but follows what the Constitutional Court directed. Thank you.
State Counsel Sikota, your 3 minutes.
Thank you very much. What is really gratifying is that there has been no denial that these words have been stated in the judgment. Accordingly, we hold that the Constitution of Zambia Amendment Bill number 7 of 2025 was not generated through a constitutionally compliant process and is therefore unconstitutional, invalid, and a nullity. That has not been denied, that is it there. Now, to try to say that if you're introducing something to Parliament in first reading, you have not initiated something, shows a total lack of seriousness. What are you bringing then? You're bringing something because you're initiating it. It's the initiation process that we're talking about. You can't run away from that. No matter how you try to contort your being and so on, the fact is the introduction for first reading means you have initiated the process. Yes, there are other processes to be taken, but you have initiated. And we're talking about the initiation having been wrong. And you can't run away from that. Now, I would like to let everybody know that the foundation of the Constitution is what is really, really important. Part of that foundation to create that sense of ownership and so on is that it must have been arrived at by consensus of the people, that it must not be contentious. Clearly, this is a contentious issue. And, Mr. President Hakainde, let me remind you, if that oath that I read, that you had read earlier on, doesn't get to you, maybe, because I'm told you're an elder in some church, maybe let me turn to the Bible. Matthew 7, verses 24 to 27, talk of a wise and a foolish builder. It says, a wise builder will build on a solid rock. The foolish one will build on sand. Our Constitution must be built on a solid rock. Mr. President Hakainde, you need to ensure that if there's cracks in the foundation, as is the case with this matter, you start afresh. Otherwise, that which you are putting together will crumble in the not too distant future. It will become a total waste of Zambia's resources. It will be taking away the faith that people have in our Constitution and in our laws. Mr. President, don't go down that route.
Thank you so much. Thank you so much, State Counsel Sakwiba Sikota, and thank you to you, State Counsel Mulambo Haimbe, for coming through and sharing your opinions, your thoughts, and your legal expertise with millions of Zambians that were listening, streaming, and watching tonight. Thank you so much.
Thank you very much.
Please, you may shake hands. Thank you so much.
Thank you.
Thank you. And believe me, we are happy that you listened to us. We only informed within a week you were calling on us.
Yes, thank you. That is democracy. We listen to it.
Thank you so much.
That's how effective was that.
The technical committee has done its report. The select committee is now hearing witnesses as the process continues in Parliament. We're waiting to see the next stages of the parliamentary processes as alluded to in the standing orders. Allow me right now to thank you all our media partners, Diamond Media, Musanza TV, Prime Television, Mafken TV, One Love Radio, Mafken Radio, Radio Mano in Kasama, Radio Delight Kwitonta in Muchinga Chinsali, KFM of Mansa, Millennium Radio Lusaka, Power FM Lusaka, Power Kabwe and Power FM Livingston, Yar FM in Kitwe, Breeze FM Chipata, Mamwe, Lundazi Nyimba, and Chadiza Katete, all the way into Sinda and Kanele FM. Online, we've been streaming on Diamond TV online as well as Diamond Media Zambia. Thank you so much for being part of this conversation. To all of you also that joined in via Zoom and contributed, the entire production team, thank you so much. We'll continue giving you these debates as we go to the election of August 2026. We'll see what Parliament will decide on debate around Constitution Amendment Bill number 7. Good night. My name is Costa Mwansa. Pleasant viewing.